Luis, you're muted. We cannot hear you.
Listo, Diego, puedes empezar. This is all.
Okay, first in Spanish. Buenas tardes y bienvenidos todos. Mi nombre es Diego Silverberg. Nos encontramos hoy aquí en el marco de la Cátedra de Cultura para la Paz y Derechos Humanos de la Facultad de Ciencias Sociales de la Universidad de Buenos Aires para asistir a la conferencia titulada Defendiendo la Justicia Constitucional, explorando los fundamentos de los derechos individuales en la era moderna. Tenemos la fortuna de contar con dos figuras destacadas en el ámbito jurídico y académico para guiarnos en este análisis. Primero, presentaré al decano de la Facultad de Derecho de Berkeley, California, el profesor Erwin Chemerinsky. Según un estudio de publicaciones legales, el profesor Chemerinsky fue el académico legal estadounidense más citado entre 2016 y 2020. Sus contribuciones al mundo jurídico y su influencia en la educación legal no tienen precedentes, como lo demuestra su nombramiento en 2016 como miembro de la Academia Estadounidense de las Artes y las Ciencias, y su elección en 2021 como presidente de la Asociación de Facultades de Derecho de los Estados Unidos. Nuestro segundo expositor es Luis David Fernández Zambrano, director de la Cátedra de Cultura para la Paz y Derechos Humanos de la Facultad de Ciencias Sociales de la Universidad de Buenos Aires. El profesor Fernández Zambrano ha organizado y participado en debates y congresos junto a docentes y titulares eméritos que actualmente trabajan en universidades de habla no hispana como Harvard, Stanford, Oxford, Cambridge, Yale, Sorbonne, entre otras. También es director del programa cultural Universidad al Aire y ha ofrecido conferencias en numerosas universidades prestigiosas alrededor del mundo. Ambos expositores contarán con un tiempo máximo de 30 minutos para presentar su visión y argumentos en relación con el tema que nos convoca hoy. Tras sus exposiciones, se abrirá un espacio para preguntas y comentarios. Les pido que mantengan la cordialidad. Ahora, now in English for the professor. Um, Good evening and welcome everyone. My name is Diego Silverberg. We gather here today under the space of the Chair of Culture for Peace and Human Rights of the Faculty of Social Sciences of the University of Buenos Aires. The subject of this conference is Defending Constitutional Justice, Exploring the Foundations of Individual Rights in the Modern Era. We are fortunate to have two distinguished figures in the legal and academic fields to guide us in this analysis. First, let me introduce the Dean of the Law School of the University of Berkeley, California, Professor Erwin Chemerinsky. According to a legal publication study between 2016 and 2020, Professor Chemerinsky was the most frequently cited American legal scholar. His contributions to the legal world and his influence on the legal education are unparalleled, as evidenced by his appointment in 2016 as a member of the American Academy of Arts and Sciences, and his election in 2021 as the president of the Association of Law Schools of the United States. Our second speaker is Luis David Fernández Zambrano, Director of the Chair of Culture for Peace and Human Rights of the Faculty of Social Sciences of the University of Buenos Aires. Professor Fernández Zambrano has organized and participated in debates and conferences alongside tenured and emeritus professors currently working at non-Spanish speaking universities such as Harvard, Stanford, Oxford, Cambridge, Yale, Sorbonne, among others. He is also the director of the cultural program University on Air and has given lectures on numerous prestigious universities around the world. Both speakers will have a maximum of 30 minutes each to present their vision and arguments related to the topic that brings us here today. Following the presentations, a space will be opened for questions and comments. I hope we can have a kind and productive exchange of ideas. Without further ado, we will begin with the presentation by Professor Erwin Chemerinsky. Please, Professor, go ahead.
Thank you for the kind invitation. Thank you for the kind introduction. It's truly my pleasure to be able to speak with you. I hope someday I'll be able to come in person to be part of a conference in Buenos Aires. I was given the topic of foundations of individual rights in the modern era. I want to answer this by focusing on the United States. This, of course, is what I know best, and I think there are ways in which the development of individual rights in the United States has an effect on the rest of the world. I would divide my remarks into 4 parts. First, a brief historical perspective. Second, talking about how rights expanded in the United States. Third, focusing on the important question of the sources of law that were used and are used to this day for the expansion of rights. And then fourth, I want to briefly talk about some of the challenges to the future that are faced in this country. Let me start with a historical perspective. I think it's often overlooked that at the founding of the United States, which of course had been a colony of England, whose law is based on English law, the source of rights depended on who was alleged to be infringing them. When it came to private infringement of rights, that's what the tort law and the contract law was for. In fact, Blackstone, in his famous commentaries on English law, said the natural law and the common law are coextensive. All of the rights that people possessed were thought to be protected by the common law against infringement from other people. But what about the government? Well, in the United States, it was thought that each state would have its own constitution, and those constitutions protect people from state and local infringement of their rights. When the United States government was created, the question was, what would protect people's rights relative to that government? And there was a great debate over whether or not the United States Constitution should enumerate rights. If you were to look at the 7 articles of the United States Constitution that were drafted and adopted in 1787, they say almost nothing about individual rights. I think if I were to do a public survey and ask people, what does the Constitution of the United States do? The immediate answer would be, it protects individual rights. But the first 7 articles of the Constitution do very little in that regard. Why not? I think some of it was that the framers of the Constitution were afraid if they tried to list some rights, that would implicitly deny the existence of other rights. They knew there was no way to list all of the rights that they wanted to protect. They believed, perhaps naively, that the structure of government that they created made it unnecessary to enumerate rights, that the structure of government would itself protect rights. But also, there is the reality. They had spent a long, hot summer in Philadelphia, and by September 17th, they were ready to go home. And so they didn't want to spend another month or two there to draft a Bill of Rights. The adoption of the United States Constitution by the states was very controversial. It passed by a close margin in a number of states, and these states insisted that a Bill of Rights be added. And 10 amendments were added in 1791. But what's important is all of these were meant limiting what the federal government could do. The First Amendment about free speech or free exercise of religion was about what Congress could do. That was true of all of the provisions of the Bill of Rights. So historically, the structure of rights in the United States was a common law to protect people from infringement of rights by private actors, state constitutions that protected people from state and local interference rights, and the United States Constitution that ideally would protect rights against the federal government. At the time of the founding of the Constitution, there was a strong belief in natural rights. In the 20th century, a belief in natural law faded, and we're much more positivists now, believing that the rights we possess are those that are enumerated. But there's always been, always will be a debate between natural law and positivism as a source of rights. Over time, the rights that came to be protected by the United States Constitution were greater than those that were protected by state constitutions or by the common law. An easy illustration: the First Amendment to the United States Constitution protects against government interference with freedom of speech. But there's not in state constitutions, and certainly not in the common law, any protection from private interference with freedom of speech. A public university can't fire a professor for speech, but a private university can, apart, of course, from contractual protections like tenure. The greatest gaps historically in the United States Constitution were with regard to race. the Constitution as drafted had no equal protection clause. That shouldn't be surprising for a document that protected the rights of slave owners. There were several provisions in the United States Constitution that specifically safeguarded those who owned enslaved persons. Congress was not able to abolish slavery for importation of enslaved persons for 20 years. The Constitution said that if an enslaved person escaped to a free state, that person would have to return to his or her owner. And so when we look at the Constitution historically, we've got to remember a tragic flaw from the beginning was the protection of the institution of slavery. A tragic flaw from the beginning was the absence of any assurance of equal protection. Well, with that brief historical background, I want to go to the second part of my remarks, and that's how rights came to expand in the United States. And here I want to talk about rights both with regard to equality and with regard to freedoms, because I would suggest that if you look over the course of American history, there has been a substantial expansion with regard to both equality and freedom. Let me start with equality. I mentioned the convention in 1787 that drafted the United States Constitution. It was 55 white men, 45% of them were slave owners. George Washington, who presided, James Madison, who took the official notes, were themselves slave owners. The Constitution, as it was drafted, was very much a document for white male property owners. It wasn't until after the Civil War, which ended in 1865, that the 13th Amendment was added to the Constitution that prohibited slavery and involuntary servitude. It was 3 years after that that the 14th Amendment was added to the Constitution that says that no state can deny any person of life, liberty, or property without due process, that no state can deny equal protection. And it was 2 years after that, in 1870, that the 15th Amendment said the right to vote can't be denied on account of slavery or previous condition of servitude. I believe that the 13th, 14th, and 15th Amendments are properly regarded, as some have called it, as a second founding of the United States. It did substantially advance equality, at least on paper. But the reality was much more limited. In the years after the Civil War, there was in the United States what was called Reconstruction, where there was military rule over the southern rebel states, and there was substantial expansion of rights for those of African descent. But that ended in 1876, and quickly, especially southern states, adopted laws to take away all rights from former slaves, those of African descent. And laws developed through the United States that required racial segregation. These laws existed in southern states, in southern parts of northern states, in border states. And in 1896, in the infamous case of Plessy versus Ferguson, the United States Supreme Court upheld separate but equal. There's a case about a Louisiana law that required that railroad cars be racially segregated. And the Supreme Court, in an 8-1 decision, said that didn't violate equal protection. Plessy versus Ferguson was the law for 58 years. This was apartheid in the United States. Every aspect of life in these states was racially segregated. Black and white children were born in separate hospitals, played in separate playgrounds, drank from separate water fountains, went to separate schools, ate in separate restaurants, ultimately buried in separate cemeteries. And it wasn't until Brown versus Board of Education on May 17th, 1954, that the Supreme Court said as to education, separate can never be equal. And it wasn't until 1964, not that long ago, that Congress adopted its first major civil rights law since Reconstruction, prohibiting race discrimination by hotels and restaurants, prohibiting discrimination in employment based on race, sex, or religion. These are enormous expansions of rights in the modern era. Congress followed this the next year with the Voting Rights Act of 1965 that meant to deal with a problem that was endemic in southern states of disenfranchising those of African descent. There remain in the United States dramatic differences between those who are individuals of color and those who are white. The difference in poverty level. A child born to a white family today has about 10% chance of living below the poverty level. A child who's born to a black family today has over a 1 in 3 chance of living below the poverty level. This is the legacy of slavery, and the gap is only slowly narrowing. So there's been an expansion of rights, but still a long way to go. It wasn't until 1971 that the Supreme Court for the first time found sex discrimination to violate the Equal Protection Clause. It wasn't until 1996 that the Supreme Court found that discrimination based on sexual orientation violates the Equal Protection Clause. So here you see there has been an expansion of equality, but it's remarkably recent. So when we talk about expansion of rights, part of it is about equality and what happened. But some of it is also about freedoms. And I would suggest that there's also been a steady expansion of freedoms that individuals possess as a result of court decisions, as a result of statutes. Let me give you a few examples of that. One concerns freedom of speech. The First Amendment to the Constitution majestically states, Congress shall make no law abridging freedom of speech. But the reality is, it wasn't until the 1920s that the Supreme Court for the first time found any federal law to violate freedom of speech. The initial cases to come to the Supreme Court were during World War I in 1919, and the Supreme Court ruled in favor of the government and against the protections of freedom of speech. Famous case here was Schenck versus United States in 1919. It involved a man who opposed American involvement in World War I. He circulated leaflets in which he argued that the military draft, conscription, was involuntary servitude in violation of the 13th Amendment. He was prosecuted for interfering with the war effort. Now, there's no evidence that his leaflet had the slightest adverse effect on military recruitment. There wasn't an iota of evidence that a single person didn't report for induction because of Schenck's leaflet. Nonetheless, the Supreme Court upheld Schenck's conviction. Justice Oliver Wendell Holmes, who's much revered in history, said, when speech poses a clear and present danger of harm, it can be punished. But of course, Schenck's speech was the antithesis of a clear and present danger. There was no indication that his speech would pose any harm. Over time, the Supreme Court came to expand protections of freedom of speech. The court in Brandenburg versus Ohio said to punish someone for incitement, and that's what Schenck was prosecuted for, there now has to be proof of a substantial likelihood of imminent illegal activity, and the speech is directed at causing it. I think a landmark in the expansion of freedom of speech came in 1964 in New York Times versus Sullivan. What was involved here was a suit for defamation. A New York Times advertisement criticized a racist sheriff in Alabama and it had very minor factual inaccuracies. It said that the song "My Country 'Tis of Thee" was sung, but it was really the national anthem. It made a mistake in the number of times that had been arrested, but all very minor. But because of this, the New York Times was held liable in a large damage judgment. The Supreme Court, in an opinion by Justice William Brennan, said that the First Amendment protects open and even vituperative discussion of public officials. That democracy depends on there being this kind of open and robust debate about those who hold offices. The court said, in order for free speech to survive, there has to be protection of some false speech too. So there'd be breathing space for the protection of expression. The Supreme Court has had an uneven record with regard to freedom of speech, but if one looks over time, it's clear that there's been more protection of speech. In the early part of the 20th century, the Supreme Court said there was no constitutional protection for movies. But now, of course, the Supreme Court is clear that all media, including very new media, the social media, the internet, are protected by the First Amendment. There was a time when the Supreme Court allowed sexual speech to be punished. Now it's unheard of to have obscenity prosecutions, unless, of course, it involves child pornography. So I think our social commitment to freedom of speech is far greater today than it used to be. I think that's both reflected in Supreme Court decisions and caused by Supreme Court decisions. A second example of the advances of freedom are those that constrain the police and prosecutors. There are several provisions in the Constitution that protect freedom by limiting what police and prosecutors can do. The Fourth Amendment to the United States Constitution says that the police can only search or arrest somebody based on probable cause that generally requires a warrant. The Fifth Amendment says there's a privilege against self-incrimination. The Sixth Amendment protects rights of trial, and these include a right to counsel, right to confront one's accusers, a right to a public trial, a right to a jury of one's peers. But if you look at the first century of American history, there were virtually no cases ever enforcing these provisions. Why not? Well, as I mentioned in my first part of the remarks, it was thought that the Bill of Rights applied only to the federal government. The federal government had a very limited law enforcement presence in the 19th century. Most policing was done at the state and local level. And so if the Constitution didn't apply to them in limiting the police, there weren't going to be cases. The first Supreme Court cases about the Fourth Amendment didn't happen until the 1890s. The first cases about the Fifth Amendment didn't happen until around the same time. This is a century into American history. To show how significant this is, it wasn't until 1932 in Powell versus Alabama that the Supreme Court said there's a right to an attorney in a state court where there's a possible death sentence. So it was for the first 145 years of American history. A state court could put somebody to death without there having a lawyer. It wasn't until 1963, in the landmark case of Gideon versus Wainwright, that the Supreme Court said anyone who's prosecuted in state court with a possible prison sentence has a right to a lawyer. It wasn't until 1961, in Matt versus Ohio, that the Supreme Court said if state and local police violate the Fourth Amendment with an illegal search, the evidence has to be excluded. And so what we see is over time, great expansion in the rights that people possess in the criminal justice system. Third and final example with regard to the expansion of freedoms concerns autonomy. The word privacy doesn't appear in the United States Constitution. There's no mention of autonomy. I think one of the great failings of the United States Constitution is not having any mention of privacy and autonomy. But the Supreme Court, for a century now, has found protection of autonomy under the liberty of the Due Process Clause. Due process clause says no state, no federal government can deprive any person of life, liberty, or property without due process of law. The Supreme Court says liberty includes autonomy. The first case about this was in the 1920s. It's a case called Meyer versus Nebraska. Nebraska adopted a law that said that children could not be taught the German language. This was adopted in World War I at a time of anti-German hysteria. The Supreme Court struck the law down, not based on freedom of speech, but by saying parents have a fundamental right to control the upbringing of their children. 2 years later, in 1925, in Pierce versus Sadia Sisters, the Supreme Court declared unconstitutional a state law that prohibited religious school education. The court again focused on the right of parents to control the upbringing of their children. Well, since then, the Supreme Court has protected many aspects of autonomy under the word liberty of the Due Process Clause. It's protected rights of family autonomy. This includes the right to marry. Think of the 2015 decision, Obergefell versus Hodges, that held that state laws that prohibit same-sex marriage are unconstitutional. The court has protected the right of parents to the custody of their children, the right to keep the family together, the right of parents to the upbringing of the children. The court has protected aspects of reproductive autonomy. The court, for example, has said there's a constitutional right to procreate. Laws that impose involuntary sterilization are unconstitutional. There's a right to purchase and use contraceptives. And until last year, for 49 years, there's been a right to abortion. The court has said there's a right of consenting adults to engage in private, consensual, same-sex sexual activity. The government can't prohibit people from engaging in homosexual activity. The court has said there's a right of competent adults to refuse medical care, even life-saving medical care. All of these are expansions of individual rights that have occurred over the course of the last decades. Well, having first given a historical perspective, and second, having talked about the expansion of rights, I want to third talk about the sources of law. And it's important in thinking about the foundations of individual rights to think about where do they come from. Most of the rights that I've talked about come from constitutional interpretation. The United States Constitution is what I've been focusing on, but states have their own constitutions. They can provide more protection of rights, just not less than the U.S. Constitution. It's interesting, there's nothing in the U.S. Constitution that creates the power of judicial review. There's nothing that says that courts can strike down federal or state laws or executive actions. It was in 1803 in Marbury versus Madison that the Supreme Court created the power of judicial review, which gives rise to the rights I mentioned. And as I've alluded to, key with regard to the Constitution is when it came in the 20th century in its protection of rights to be applied to state and local governments. In the United States, most governance is still done at the state and local level. Education is a state function. Policing is mostly done at the local level. And so it's so crucial in expanding rights to apply the Bill of Rights to state and local governments. Statutes can provide protection of rights greater than the Constitution. It can be federal statutes for the whole country. It can be state statutes. I mentioned earlier the Civil Rights Act of 1964 that for the first time said that hotels and restaurants can't discriminate based on race. That for the first time said that employers can't discriminate based on race or sex or religion. And statutes can provide greater protection of rights. As an example, the United States Constitution and its protection of free speech applies only to the government. But states can, if they want, provide protection of speech against private entities. In California, there's a law, it's called the Leonard Law, that says that private colleges and universities and high schools cannot punish speech that the government can't punish because of the First Amendment. The First Amendment applies only to the government. but a statute in California limits the ability of private actors to infringe speech. A final source of protection of rights is still the common law, tort law, contract law. But as I alluded to at the beginning, the common law has not kept up with constitutional law and protection of rights or statutory protection of rights. But it is still a source that can be there. Well, this leads me to the fourth and final part of my remarks, the challenge for the future in the United States. As you know, the United States is deeply politically divided. I believe it is more polarized now than it's been at any time since Reconstruction or the Civil War. There is right now a very conservative Supreme Court. It has 6 justices who are appointed by Republican presidents and are regarded as very conservative, 3 justices appointed by Democratic presidents who are liberal. And it's likely to be this way for a long period of time. Clarence Thomas, well, as I think you know, Supreme Court justices and federal judges in the United States have life tenure. It's the only country in the world where that's true. Clarence Thomas went on the Supreme Court in 1991, but he's still only 75 years old. Samuel Alito is 73. John Roberts is 68. The 3 justices picked by Donald Trump, Neil Gorsuch, Brett Kavanaugh, Amy Coney Barrett, are all in the 50s. So it's easy to imagine this group of justices remaining for some time. This is a group of justices that are very much in accord with current conservative ideology. They are the ones who eliminated abortion rights under the Constitution a year ago. They are the ones who just 2 weeks ago said that no longer can college universities engage in affirmative action. So they seem to be narrowing some rights under the Constitution. They are, to be sure, expanding other rights, like gun rights and the Second Amendment. I think that the question for the future in the United States is going to be, what will it mean at a time when our country is so polarized to have a Supreme Court that's come down on one side of that divide? The Supreme Court has its lowest approval ratings in history. A poll by Quinnipiac University just last month had 30% expressing approval of the Supreme Court and 59% expressing disapproval. A Gallup poll said only 25% of the American people expressed confidence in the Supreme Court. And I think the challenge for the future is, will there continue to be expansion of equality and freedom in light of the composition of the court? Ultimately, I take hope from the sweep of American history. I think the late Dr. Martin Luther King Jr. got it exactly right when he said, "The arc of the moral universe is long, and it bends towards justice." Thank you.
Well, Luis David, estás muteado, pero te toca a vos para tu exposición.
That's right. All right. Very
Proceed.
good. Okay. Good afternoon, distinguished friends and colleagues from across America and around the world. My sincere hope is that each one of you is enjoying excellent health and is surrounded by the warmth of your loved ones. First and foremost, allow me to express my deepest gratitude towards our esteemed colleague, Mr. Erwin Chemerinsky, whose academic excellence has enabled him to assume the prestigious role of Dean of the Law School at the University of Berkeley. Located in our sister nation, the United States of America, today he has generously offered to share his vast knowledge and experience with us, shedding light on the challenges and opportunities that individual rights faced in the modern era from a constitutional perspective. We are greatly honored by his presence, considering the insignificant influence he has had in the American legal field up to becoming one of the most respected constitutionalists in the homeland of Ralph Waldo Emerson. On behalf of myself and my colleagues and authorities from the Faculty of Sociality Science at the University of Buenos Aires, we extend our most cordial greeting. We will absorb every detail of the conference and strive to disseminate and content appropriately through various academic and cultural channels at our disposal. My sincere thanks for the privilege. My esteemed colleague and friends Erwin Chemerinsky. The honor of addressing you today aims to strengthen our interdisciplinary visions around issues of immense relevance in these modern times. We are at crucial crossroads, considering the fit of individual rights amid constitutional and governmental challenges around the world. Before proceeding, I want to clarify that the opinions I will share today represent only one of the many possible perspectives when examining this social-legal phenomenon. I do not intend for the conclusion derived from this dialogue to be universally valid, but rather I hope that they will serve to expand our perspective and enrich our approaches. I do not seek to flam the flag of absolute truth, but to open a space for reflections and dialogue based on this principle. I have structured my presentation in three core areas of analysis. First, I will focus from a methodological perspective on the philosophical, sociological, and scientific nature of the individual rights, exploring their relationship with the constitutional structure and the dynamics of the power underlying these selected legal categories. From these reflections, we will analyze the challenges and opportunities that we face as teachers and the researchers, aiming to challenge the limits of classical constitutionalism and try to solve a paradigmatic change in the epistemological, sociological, and philosophical foundation that have nourished constitutional law to this day. Secondly, I will explore from a discrete perspective the role played by the most recognized and accepted individual rights, such as freedom of speech and freedom of thought, and how they relate to the current the social and political atmosphere in the different parts of the world. We will not shy away from mentioning the crisis of democratic representation, the challenges of the right to culture and the civic education to expand democratic lucidity and reason, and the challenges of the constitutional law interpretation in the face of the trend to other strictly to traditions. Finally, I will present a resolutive perspective or a possible path to face the current and the secular crisis that we face as human beings, strategically articulating the, the stakes and private sector within a framework heavily impregnated by artificial intelligence. I hope that together we can shed light on this topic and work towards VR and just solutions. Thank you for attention. Let's uh, move now to the seconds our analysis. It is polarizing world we live in the world, in the political and religious ideas are reaching the zenith. Uh, it's very important to understand that freedom of thought and expression is in great danger. Intolerance and contempt for the ideas of others are taken on the increasingly hostile form in the various aspects of social life, social networks, unfortunately, and often the perfect stage and magnify this conflict. People insult each other on resort to ad hominem fallacies and their discussions. Um, there are also certain controversial Supreme Court decisions in the United States that hack supreme freedom of speech of certain websites based solely on the sexual orientation of their administrators or managers. I want to clarify that this recent Supreme Court ruling demonstrates that justice and law, unfortunately, do not always follow the same path. Have law and justice always advances together on the path of history. At this point, I share the perspective of the Greek philosopher from the University of Oxford, Herbert Leonard Adolf Hart. Um, in his book, The Council of the Law, argues that the relationship between justice and law is contingent. Sometimes justice coincides with the law, and other times it does not. For example, Nazi Germany established through its legislation that it was an illegal act for a German to hide Jews in their home. This was for the Nazis an illegal practice um, that deserved drastic punishment. However, many people did it anyway because they understood that law and justice do not always coincide. On occasions, it is more worthwhile to beg on justice than on the law. Just as the Shaw brothers did, you defy the legality of their country's courts and allows initials seeing the bad guys of the story. Over time, they were activity and proved that they were right. Becoming becoming heroes in various society of our times. There are people who absolutely venerate of the decision made in the Supreme Courts and Congress of their respective countries, regardless of the whether they are fair or unfair. However, they forget that a large parts of the civil, labor, and economic rights that we currently enjoy have their beginning thanks to the rebel with a cause. those who cross the line from the rule of law to the empires on justice. Similarly, with the rights to freedom of expression. In the time of Galileo Galilei and Nicholas Copernicus, when it was claimed that the earth was not flat, that our planet revolved around the sun and not the other way around. They were seen as the madmen, heretics, the rebels, those who discredited science. However, who will now think that these ideas, considered back in their time, lack validity and sensitive backing. I morality and intellectuality support my college at the University of Berkeley. You of the justice instead of law when they defend civil rights and the complex world full of contradictions. However, I must caution that postmodernism is a phenomenon to be considered with care to do its dangerous reverberations in our system. Postmodernism is anti-scientific and directly opposes our mission as educator or disseminator aiming to construct rigorous scientific methods for our disciplines. Constitutional postmodernism must be scrutinized with great care, but those who love clarity and reason, where identity political unite with the constitutional reason, they often conceal demagogic visions more than realistic ones. Historically, there are sector excludes for reason of race, sex, or ideological orientation, but is that not seen appropriate to meet to validity of privilege a human being basic for on superficial matters, such as skin colors or last names. In this sense, I strongly disagree with Roberto Carcarella when he argues that we cannot have a conversation among equals. Equality does not exist because the world is shaped from diversity in the broadest sense of the term. Even morality, we all cannot be equal in practice, perhaps in various constitutional narratives. It is now recognized that we all have the right to vote. However, when this legal idea is put into practice, we find it does not work that way. For instance, the Peruvian Constitution in Article 31, 31 declares that everyone has the right to vote in practice. Um, However, it does not work that way. A large number of the personnel from the National Organization of Electoral Process of Peru, they cannot actually exercise the vote, despite it being recognized as a constitutional right. Impartiality criteria are often invoked in the development of the electoral event to choose mayors and presidents. Like the case, we can find many similar ones in various countries worldwide where reality tools and tools are to be totally different dimensions from theory. As constitutional law scientists, we must work more according to reality dark theory. And this current reality in this says that even universal equality cannot exist when exercising the vote. However, diversity is no bad. Diversity is no bad. On the contrary, learning to live in racial, political, and religious diversity is wonderful opportunity to grow as human beings, as long as respect and diplomacy prevail in our dialogues and debate or debates. Um, Thus, we will develop the right to tolerance and respect in the most commendable way possible within the most interesting framework of the term. To conclude this presentation, I want to emphasize that every era and place present its own unique needs. Therefore, our legal and constitutional framework, while respecting classical tradition, must expand its boundaries in response to the changing rings and challenges of the modern world. Um, we face two phenomena such as artificial intelligence and cybercrime that were never contemplated by the authors of the Federalist Papers. They teaches us that reality advances at a faster pace than the law, and the law in turn must anticipate and adapt to emerging changes. Our priority as a nation and as a global community must be to promote massive access to culture and education for many people and possible civil rights related to freedom of expressions and opinion can only be exercised effectively and beneficiality in an environment of mutual respect and tolerance, and in which people are well educated, enlightened, and passionate about dialogue. A year ago, I had the privilege of the debating with Samuel Isacharov about the need to prioritize the development of libraries and culture, literary and philosophical spaces in all communities of our country. We need to stimulate critical thinking and adaptability to changing political and economic system. It's also essential to foster the culture of intellectual debate from the home to most elaborate arenas and modern life, returning to freedom of expression. I underscore that this right will exercise more fully when we form more tolerant, wise, and respectful human rights. I firmly believe that philosophical discipline can greatly help in this challenge from our schools and universities. Just as Socrates taught us to use the meiotic method in the 5th century ante the Cristo. We must incorporate is in our classroom. This method will allow us to share our students with great open-mindedness, greater capacity for tolerance, and greater ability to find unity amid diversity. Furthermore, honoring the silence of law um, I recognize that various investigations have shown how nutrition influences our behavior. Processed foods, omnipresent in many of our styles, can lead to more violent or aggressive behavior, especially in children. Aristotle already asserted that man is the only animal that dig his grave with his teeth. In this sense, their responsibility to ensure that constitutional achievement do not become that letter to social pressure that do not solely on the home. Government aspiring to build and solid democracy must strive to promote good public health in the biological, emotional, and mental sphere in order to promote in the culture of the peace and development in our modern societies. In conclusion, I thank you all for your time and patience in listening to me. I had never considered myself to possess the ultimate truth in life and always willing to listen to opinion and suggestions from distinguished colleagues to continue advancing in the world of knowledge from the bottom for my heart. Infinite thanks. Thanks very much.
Thank you, Luis. Well, Professor, did you had any trouble understanding Luis in his speaking? Do you want me to summarize some point or something like that?
I think I could understand most of it, and I'm glad to take questions if there are any.
Okay. Um, well, I've written some specific questions. Some are kind of connected to what Luis just said, so feel free to decide which. Okay, as we know, society is a living being in continuous change, but a constitution is a relatively fixed document, even when we modify it over time. What kind of problems do you think arise from this situation, or and is it possible to reconcile these kind of contradictions? You can.
What makes a constitution different from all other laws is how difficult it is to change. In the United States, any other law that's adopted by a legislature can be changed by that or a future session of the legislature. But changing the United States Constitution is very difficult. It takes 2/3 of both houses of Congress and then 3/4 of the states. There is a virtue to that in that it provides stability for government. But I think there's also a disadvantage to that in that it's very difficult then to adapt the Constitution to modern needs. I think that the question is, how hard should it be to change a Constitution? We all agree it should be more difficult than it is to change a statute. I think the framers of the American Constitution made it too difficult. Since 1791, when the Bill of Rights were adopted, there have only been 17 amendments to the US Constitution, and 2 of those were to create prohibition of alcohol and then repeal the prohibition of alcohol. And so if I could go back and redesign the US Constitution, I wouldn't make it so impossible to amend. I think that it's difficult to be governed under a document written in 1787 for an agrarian slave society. It needs to be updated, but it's almost impossible to do that.
Okay. Okay, our next question. Okay. With regards to the interpretation of the Constitution, Imagine we find a certain subject that is not addressed by the Constitution, and then we decide to read the whole text to interpret and give an answer to that specific point. Can we say we are expressing the will of the Constitution or the people, or are we kind of using the Constitution as a vehicle to express our own biases or will?
It's so difficult to be governed from a document that was written in the 18th century. There's a major debate in the United States among Supreme Court justices and among academics as to how to interpret the Constitution. One school of thought in the United States is called originalism. And originalists believe that the meaning of a constitutional provision is fixed when it's adopted and changed only by amendment. So to go to your question, an originalist say, we're just trying to carry out what was the original meaning of the document when written in 1787 or whenever the amendment was adopted. Non-originalists say it makes no sense to be governed by what people thought in 1787, even if we could figure out what they thought. I mean, think about it. What did the framers of the Constitution think about how social media like Facebook can be regulated? What did the framers of the Constitution think about whether the government can regulate violent video games? It's an absurd question. Or take the gun issue. There weren't assault and semi-assault weapons like AR-15s in 1791. So how can we ask, what did the framers in 1791 think about AR-15 assault weapons? Also, the reality is that if we were to follow what people thought when the Constitution was written, it would lead to some abhorrent results. I think one of the most important Supreme Court decisions in history in the United States was Brown versus Board of Education that said that separate can never be equal. But the same Congress that ratified the 14th Amendment in 1868 also voted to segregate the District of Columbia public schools. If one followed the framers' views from 1868, states could still prohibit interracial marriage, let alone prohibit marriage between same-sex couples. So I think if the Constitution is going to be relevant, it has to be interpreted for our time. It can't be limited to what they thought then. Does that then mean that the justices are making value choices based on our time? Yes, but I don't see any alternative if we're going to live under a document adopted so long ago.
Okay, interesting. With regards now to freedom of speech, if we speak about liberty or freedom of speech, this requires certain material conditions. If we pretend everyone to have the same level or the same volume of voice in public society, should we also make an argument about equality in general for society?
Yes, I think that freedom of speech advances equality and is founded on equality, but it can also be a threat to equality. What I mean by that is freedom of speech is a right that everyone gets, and the government can't give some people more speech rights than others. The government, the law is clear, can't prohibit speech from being expressed because it doesn't like the viewpoint. There is a principle of equality in terms of all of us, whatever our views, have the same right to speak. And freedom of speech is tremendously advanced equality in the United States and in other countries. Think about in the United States, the civil rights protests, the lunch counter sit-ins that advanced equality. But also think of freedom of speech in other countries and how much it's advanced liberty and equality in those places. But there's also a way in which freedom of speech can threaten equality. Think of hate speech. In the United States, unlike most Western countries, hateful speech, racist speech, anti-Semitic speech, homophobic speech is protected by the First Amendment. And that can certainly undermine equality. So the relationship between freedom of speech and equality is a complicated one.
Okay. Well, with regards to that, we have recently seen a tendency in the United States, particularly on state level, of anti-LGBT politics. In that sense, my question is hate speech a manifestation of the ideas of society, or is the manifestation of certain particular groups that have louder voices or greater access to means of expressing their ideas? And what should we do about it?
I think the answer to your question is yes, it's both. Hateful ideas are present in every society. There's probably no society in the world where there aren't people who are racist or homophobic or anti-Semitic. I think one of the unfortunate developments in the United States over the last several years is there's been much more expression of such hate. There's a tremendous increase in anti-Semitic acts in the United States in the last few years, certainly a significant increase in attacks on gays and lesbians, and all of this accompanied by more hateful speech, more racist speech, more anti-Semitic speech, more speech against gay and lesbian rights. Some of it is, I think, that it's become more acceptable to express this openly. And I think we think about why and what role social media has played in that, what role Donald Trump played in that. I think some of it is that there are leading politicians like Florida Governor Ron DeSantis who thinks that he can gain political advantage by attacking lesbian, gay, transgender rights. And so I think that's why we see more speech like that. But it's tremendously discouraging to see the increase in anti-LGBT speech and the increase in hate crimes that accompany it.
Okay. Well, Luis, do you have, Luis, ¿tenés alguna pregunta vos para hacerle a Erwin? Estás muteado.
Sí, sí, justamente the question está relacionado this relation with the liberty, with the equality, the conditions in the human in the planet for the idiomatic and economic biological structure. ¿Por qué White? ¿Cómo podemos hablar? Y eso quiero que le traduzcas al profesor. O sea, ¿por qué en este contexto, in the world,
Okay, I will translate.
ya, quiero que le traduzcas eso al profesor. Quiero que le digas, ¿por qué tanto se habla de libertad, igualdad y que son ideales de la Revolución Francesa? Cuando en la vida práctica todos estamos acondicionados. Émile Durkheim, que es un sociólogo muy famoso en Francia en el siglo XIX, hablaba particularmente de que todos estamos acondicionados por la política, por el idioma, por las cuestiones económicas. La libertad y el libre albedrío, que son ideas religiosas, ¿por qué tienen que ser toleradas por académicos que apuestan por la investigación científica? ¿Acaso la ciencia está más ligada a la escolástica, que es un tiempo en donde la idea de libertad floreció, que la visión más científica, que fueron, por supuesto, los filósofos del siglo XIX que tumbaron todas esas ideas? Más o menos quiero saber su visión, o lo considero de una manera muy acrónica.
Okay, Luis, Luis's question is along the side of we are all conditioned in society, as Emil Durkheim said, by several factors. We could speak about all of them. But yet, when we speak about freedom of speech, we speak with this kind of words like liberty of freedom that have profound philosophical meaning. Luis associates these words with scholastics, with more like religious history rather than scientific one. And shouldn't we use modern or more scientific, more recent words, maybe, or should we keep using these words, or why are we using them?
I'm not sure I understand the question. Let me try.
Okay.
I think we use the words because they're familiar to us. I think that we use the words because we think that they're going to communicate to an audience the message that we want to express. I think it's very difficult to change language, but there's no doubt that language confines the thoughts. Language confines what we're able to express to others. Am I addressing the question, or am I missing that question?
I think he's asking if we should use a more scientific language.
I think it depends on what we're talking about. I think in the realm of science, we should use a scientific language. I think in the realm of constitutional law, I don't think there is such a thing as a more scientific language. I think that there are certainly places where we need to be more precise in our choice of words, but I don't think that it's a scientific language that we're looking for.
That's right, professor de Erwin Chemerinsky. Ok. Diego, ¿puedes hacerle una última pregunta? Dile que si bien the academic United States in the world is very conservative, o sea, es muy conservadora, pero dile cómo los profesores en Estados Unidos pueden romper con ese conservadurismo lanzando giros copernicanos, o sea, cambiando toda la estructura. Regulation structure of, speaks in the constitutionality in United States. O sea, porque la academia es muy conservadora, pero se supone que los profesores deben dar el puntapié para dar los grandes cambios en el lenguaje, en la realidad, porque son los principales actores para poder llevarlo a cabo with students, with college, in the other space academic in the planet. ¿Puedes más o menos darle esa idea, por favor, please?
Ahí estoy. Okay, Luis is asking, given that the academia, with regards to constitutionalism, is tending to conservatism and is generally seen as that, what can we do? What can people do to create what he calls a Copernican revolution in the area, in the field?
In the United States, professors, after a certain point in their career, receive tenure. It means it's very difficult to fire them. And there's a strong tradition in this country of academic freedom, not firing professors for what they say. So my answer to this is that I think it's so important that academics be courageous and speak out. And that includes speaking out against the Supreme Court. I think to the extent that our Supreme Court has been taking away people's rights, we need for professors to be the leaders in saying that what the Supreme Court's doing is wrong.
Okay.
That's question. Se supone, digamos, que Diego Silverberg, amigo, por ejemplo, él sostiene esa idea, pero lo que pasa particularmente noto de que los ideólogos del liberalismo clásico son very important, o sea, son muy importantes. Liberalism classic. Because, however, perdón, please, however, sin embargo, yo siento de que estos nuevos profesores del constitucionalismo no tratan de ser muy muy vanguardistas, porque yo veo que se quedan atrapados con el mismo lenguaje de hace 3, 4 siglos, cuando el lenguaje, como toda la naturaleza, está en constante cambio. Heráclito de Efesos, Heráclitos os Efesos. Nadie puede bañarse 2 veces en un mismo río. Y ahí donde la teoría de la interpretación jurídica constitucional del originalismo, the originalist, es, para mí, es muy polémica, porque el constitucionalismo va modificándose conforme avanzan las circunstancias. Si el constitucionalismo se modifica by the time and space in the world, ¿por qué nosotros tenemos que quedarnos con una parte y por no avanzar también en el plano del lenguaje? Pero también, digamos, eso no reconoce que los seres humanos tengan the rights, tengan también the human rights, o sea, tengan derechos humanos, tengan un montón de dignidad. O sea, más o menos, no sé si puedes centrar estas ideas y lanzarles, porque yo siento eso particularmente.
Okay, I'll do my best. Okay, Luis is asking, he says that new people studying constitutionalism, new professors, new students, find themselves kind of thinking the same things that the previous generations think. And how can we break through that and like more or less that part?
In some ways, we can't. The underlying issues are eternal. They're going to exist as long as there are people. How do you balance liberty and equality? Any law that prohibits discrimination limits the freedom to discriminate. What's the right balance between liberty and equality? That's going to be there as long as there are people. If we're designing a government, what powers do we want to give to the government? What powers do we want to give to the courts? Those questions will always be there. And so if the questions will always be there, then there's a way in which the discussion will be there. The debate between formalism and non-formalism, or between natural rights and positivism, has always been there and it always will be there. And yet I think that in every generation, there are new ideas. It's not just replicating the ideas of the past. Originalism in the United States, which I think is a terrible theory, didn't develop until the 1970s. And of course, then there were different versions of originalism. New theories of rights and justice get developed. I think of in the United States, Ronald Dworkin and his magnificent work, Taking Rights Seriously. Or before that, John Rawls and his philosophy with regard to rights. I don't think they were just rehashing what had been said before. So I think my answer to your question is, the questions are eternal, but each generation comes up with new things in answering them.
Estás muteado, Luis.
Bien, fantástico. Me encantó la respuesta. Yo solamente voy a hacer una última pregunta porque el tiempo también nos amerita.
Okay.
Quería preguntarle algo muy concreto. Las investigaciones neurocientíficas están determinando, the Neuroscience Research, están investigando de que el libre albedrío es cada vez más una utopía que una realidad. Si bien las ideas, los lenguajes, están bien difícil que se modifiquen de un día para otro, porque, bueno, la Corte Suprema de Estados Unidos es un claro ejemplo, pero no se supone que particularmente, bueno, más allá de que los profesores puedan darle puntapié, todas las investigaciones sociológicas y científicas que se vienen trayendo del siglo XIX hacia adelante puedan servir como un fundamento claro. Ahora, él menciona mucho el tema de la discriminación. John Rawls tiene un libro muy bueno, se puede discutir, que es sobre la justicia, The Justice. Pero Rawls habla mucho de la discriminación positiva y la discriminación negativa. Ahora, esa idea de discriminación para mí, más que discriminación es desigualdad. Una desigualdad que es aceptable, una desigualdad que es inaceptable. Y más que es una cuestión liberal, es una cuestión de la realidad concreta. En el mundo nadie es igual, todos somos altos, bajos, más jóvenes, más viejos. Pero ¿cómo se puede entender, digamos, estas teorías liberales de Rawls bajo la lectura de Erwin Chemerinsky, que apuesta, por ejemplo, por la categoría de libertad en un contexto en donde los fallos de la Corte Suprema son cada vez más ajenos a estas ideas. Y parece que el posmodernismo está entrando ahí. ¿Cómo ve ese tema? Y ahí acabo.
A ver, ¿podés reformularla? Porque no estoy seguro de haberla entendido yo como para traducirla. Estás muteado de nuevo. Sí.
Ya, sí, this is fantastic. ¿Cómo ve el profesor Erwin Chemerinsky la llegada, digamos, de la política post-McCarthy a la narrativa constitucional en Estados Unidos, que tiene mucho que ver, digamos, con el tema de la raza, el género, y desconsidera otras variables del marco social que tienen que ver mucho con la categoría, bueno, aparte de clase, la categoría de ser humano, porque un negro, un blanco, un chino, un estadounidense, un peruano, un argentino, en el fondo son seres humanos. ¿Y por qué no lo vemos de esa categoría? ¿Y por qué dar más privilegios o menos privilegios a una persona simplemente por el color de piel? Capaz su abuelo puede haber sufrido, pero la persona que está acá no tiene por qué cargar las ventajas ni desventajas de una persona. Capaz su abuelo puede haber sufrido, su padre se ganó la lotería y pasó otra cosa. Barack Obama es un claro ejemplo de cómo alguien que es, ok, fantástico.
Okay, so Luis's question is with regards to affirmative action and kind of policies related to that. He argues that why do we accept certain categories and not others? Like, why do we accept race or gender, and why don't we use other categories? ¿Qué tipo de categorías, Luis? What kind of qué tipo? The
clase, the human,
Yeah.
self.
Or like other categories like class, for example. Or,
Sure.
Yeah.
I know we're almost out of our time, and so I'll try to answer quickly. The question is, will we achieve diversity without making a special effort to do so through affirmative action? Let me take the example of sex and law schools. My law school is now 65% women students. We don't give any benefit in admission on the basis of sex. We pay no attention to sex because we don't need to. We have diverse students without it. We don't need to worry about giving a benefit for religious diversity because we get religious diversity without it. But given the history of racism in the United States, if we don't take into account race, if we're race blind, there won't be very many students of color, especially there won't be very many African American students. And this reflects the long history of discrimination. And so where affirmative action is used is where it's necessary to achieve diversity. With regard to socioeconomic status, if we can't achieve diversity in socioeconomic status without some form of affirmative action, we need to do that too. But I think the goal of an American law school or university should be have a very diverse student population. And the question is, can we achieve it without some form of affirmative action?
That's right. Diego, voy a finalizarme. Bueno.
Okay, el cierre.
Okay, yes, please.
Well, it has been a pleasure to host this conversation. Do any of you want to say goodbye as your own way?
It's been an honor and a pleasure to do this. Thank you so much for inviting me.
¿Puedo utilizar la palabra? Please, moment. My dear college, friends, student, the path of learning and the search for truth is long and arduous. However, it some weeks the most beautiful rewards, the illumination of knowledge and deep understanding of our society and ability to shape the world for the better. The flame of curiosity, that which burns in the heart of each one of us, not only drives us to acquire more knowledge, but also to question, challenge, and explore and make territories of human understanding. Every time the flame is lit, a path opens to a better world, a more just society, and a brighter future. I firmly believe at each one of us, with our passion for truth, our commitment to justice, and our willingness to learn and grow can be a beacon of hope and change. Today, looking at each of you and don't just see a student, teacher, and professional. I is future leaders, visionaries who can and will change the world. Remember that education is not has a door to individual opportunities. Um, but also a matter key on unlocking the progress of our society. Our responsibility as educators, leaders, and citizens is to ensure that this key is within everyone's reach. Law in its many forms and manifestation is one of the fundamental pillars of our society, and each one of us has the power and responsibility to contribute to its constant evolution and improvement. So, as we conclude our conference today, I invite you all to continue this journey with determination and hope. Let's share with us the words we have shared, the ideas we have explored, and allow them to guide our actions and thoughts. But above all, let's remember we are a world, one humanity united in your diversity and strength. My sincerity thanks for your participation in this event. It has been an honor and a pleasure to learn, to grow, and explore alongside you. Together, we will move towards a future of greater understanding, greater justice, and a greater love for the truth. Infinite thanks.
Well, gentlemen, has been a pleasure. Okay.